Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Reed v. Goertz. In this case, the court consider this issue: when does the statute of limitations for a 42 U.S.C. section 1983 claim seeking DNA testing of crime scene evidence begin to run? The case was decided on April 18, 2023. The Supreme Court held that when a prisoner pursues state post-conviction DNA testing through the state-provided litigation process, the statute of limitations, a procedural due process claim under 42 U.S.C. section 1983, begins to run when the state litigation ends. Justice Brett Kavanaugh authored the 6-3 majority opinion holding that, in Reed's case, the statute of limitations on his section 1983 claim began when the Texas Court of Criminal Appeals denied his motion for rehearing, not when the state trial court denied DNA testing. A statute of limitations begins to run when a plaintiff has a complete and present cause of action. When that occurs depends on the cause of action. The violation of procedural due process rights, as Reed alleged in this case, requires two elements. 1. Deprivation by state action of a protected interest in life, liberty, or property, and 2. Inadequate state process. Thus, a plaintiff has a complete and present cause of action for a procedural due process violation, not at the time of deprivation, but at the time the state fails to provide due process. In Reed's case, the state's alleged failure to provide him with a fundamentally fair process was complete when the state litigation ended, and deprived Reed of his asserted liberty interest in DNA testing. Justice Clarence Thomas dissented, arguing that the district court lacked jurisdiction to hear the case for lack of standing. Justice Thomas would dismiss the case on the finding that Reed's action presents no original Article III case or controversy between him and the district attorney. Justice Samuel Alito authored a dissenting opinion, in which Justice Neil Gorsuch joined, arguing that there are a number of points in the case at which the statute of limitations could begin to run, all before the denial by the Criminal Court of Appeals, and all leading to the conclusion that Reed's claim is time-barred. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kavanaugh delivered the opinion of the court. In many states, a convicted prisoner who still disputes his guilt may ask state courts to order post-conviction DNA testing of evidence. If the prisoner's request fails in the state courts and he then files a federal 42 U.S.C. section 1983 procedural due process suit challenging the constitutionality of the state process, when does the statute of limitations for that section 1983 suit begin to run? The 11th Circuit has held that the statute of limitations begins to run at the end of the state court litigation denying DNA testing, including the state court appeal. In this case, by contrast, the 5th Circuit held that the statute of limitations begins to run when the state trial court denied DNA testing, notwithstanding a subsequent state court appeal. We conclude that the statute of limitations begins to run at the end of the state court litigation. In 1996, Stacey Stites was strangled to death in Bastrop County, Texas. The state charged Rodney Reed with murdering Stites. At trial, Reed claimed that he was innocent and that Stites' fiancée or another acquaintance had committed the murder. A jury rejected that defense theory and found Reed guilty. Reed was sentenced to death. The Texas Court of Criminal Appeals affirmed the conviction and death sentence. Reed's state and federal habeas petitions were unsuccessful. Then in 2014, Reed filed a motion in state court under Texas's post-conviction DNA testing law. Reed requested DNA testing on more than 40 pieces of evidence, including the belt used to strangle Stites. Reed contended that DNA testing would help identify the true perpetrator. The state prosecutor, Respondent Brian Goertz, agreed to test several pieces of evidence, but otherwise opposed the motion and refused to test most of the evidence. The state trial court denied Reed's motion. The court reasoned in part that 1. Many items Reed sought to test, including the belt, were not preserved through an adequate chain of custody, and 2. Reed did not demonstrate that he would have been acquitted if the DNA results were exculpatory. On appeal, the Texas Court of Criminal Appeals affirmed the trial court, and later denied Reed's motion for rehearing. Reed next sued in federal court under 42 U.S.C. section 1983, asserting that Texas's post-conviction DNA testing law failed to provide procedural due process. Among other things, Reed argued that the law's stringent chain of custody requirement was unconstitutional, and in effect, foreclosed DNA testing for individuals convicted before rules governing the state's handling and storage of evidence were put in place. The U.S. District Court for the Western District of Texas dismissed Reed's complaint. The U.S. Court of Appeals for the 5th Circuit affirmed on the ground that Reed's Section 1983 suit was filed too late, after the applicable 2-year statute of limitations had run. The 5th Circuit ruled that the statute of limitations began to run when the Texas trial court denied Reed's motion, which occurred more than 2 years before Reed filed his Section 1983 suit in federal court, not when the Texas Court of Criminal Appeals denied rehearing. Because the federal courts of appeals disagree about when the statute of limitations begins to run for a Section 1983 suit regarding a state's post-conviction DNA testing procedures, we granted certiorari. Texas raises 3 threshold arguments. First, Texas argues that Reed lacks standing. We disagree. Reed sufficiently alleged an injury in fact, denial of access to the requested evidence. The state prosecutor, who is the named defendant, denied access to the evidence and thereby caused Reed's injury. And if a federal court concludes that Texas's post-conviction DNA testing procedures violate due process, that court order would eliminate the state prosecutor's justification for denying DNA testing. It is substantially likely that the state prosecutor would abide by such a court order. In other words, in terms of our standing precedent, the courts would have ordered a change in a legal status, and the practical consequence of that change would amount to a significant increase in the likelihood that the state prosecutor would grant access to the requested evidence, and that Reed therefore would obtain relief that directly redresses the injury suffered. Second, Texas invokes the state's sovereign immunity, but the Ex parte Young doctrine allows suits like Reed's for declaratory or injunctive relief against state officers in their official capacities. Third, Texas contends that Reed's procedural due process claim contravenes the Rooker-Feldman doctrine. That doctrine prohibits federal courts from adjudicating cases brought by state court losing parties challenging state court judgments. But as this court explained in Skinner v. Switzer, even though a state court decision is not reviewable by lower federal courts, a statute or rule governing the decision may be challenged in a federal action. Here, as in Skinner, Reed does not challenge the adverse state court decisions themselves, but rather targets as unconstitutional the Texas statute they authoritatively construed. This court's case law severely limits the federal action a state prisoner may bring for DNA testing. The court has rejected the extension of substantive due process to this area, and left slim room for the prisoner to show that the governing state law denies him procedural due process, seeking to fit his Section 1983 suit within the slim room left by this court's precedent. Reed raised a procedural due process challenge to Texas's post-conviction DNA testing law. The sole question now before this court is whether Reed's Section 1983 suit was timely. The parties agree that the statute of limitations for Reed's claim is 2 years, but the parties disagree about when that 2-year limitations period began to run. That question is one of federal law. As a general matter, the statute of limitations begins to run when the plaintiff has a complete and present cause of action. To determine when a plaintiff has a complete and present cause of action, the court focuses first on the specific constitutional right alleged to have been infringed. Here, the specific constitutional right allegedly infringed is procedural due process. A procedural due process claim consists of 2 elements: I, deprivation by state action of a protected interest in life, liberty, or property, and 2, inadequate state process. Importantly, the court has stated that a procedural due process claim is not complete when the deprivation occurs. Rather, the claim is complete only when the state fails to provide due process. Reed contends that the state's process for considering his DNA testing request was fundamentally unfair in violation of the Due Process Clause. Texas's process for considering a request for DNA testing in capital cases includes not only trial court proceedings, but also appellate review by the Court of Criminal Appeals. And under long-standing Texas rules of appellate procedure, the Court of Criminal Appeals' appellate review process encompasses a motion for rehearing. In Reed's case, the state's alleged failure to provide Reed with a fundamentally fair process was complete when the state litigation ended, and deprived Reed of his asserted liberty interest in DNA testing. Therefore, Reed's Section 1983 claim was complete, and the statute of limitations began to run when the state litigation ended, when the Texas Court of Criminal Appeals denied Reed's motion for rehearing. The soundness of that straightforward conclusion is reinforced by the consequences that would follow from a contrary approach. If the statute of limitations for a Section 1983 suit like Reed's began to run after a state trial court's denial of a plaintiff's motion for DNA testing, or even after the appeal before the plaintiff's rehearing proceedings, the plaintiff would likely continue to pursue relief in the state system, and simultaneously file a protective federal Section 1983 suit challenging that ongoing state process. That parallel litigation would run counter to core principles of federalism, comity, consistency, and judicial economy. We see no good reason for such senseless duplication. Moreover, significant systemic benefits ensue from starting the statute of limitations clock when the state litigation in DNA testing cases like Reed's has concluded. If any due process flaws lurk in the DNA testing law, the state appellate process may cure those flaws, thereby rendering a federal Section 1983 suit unnecessary. And if the state appellate court construes the DNA testing statute, that construction will streamline and focus subsequent Section 1983 proceedings. In sum, when a prisoner pursues state post-conviction DNA testing through the state-provided litigation process, the statute of limitations for a Section 1983 procedural due process claim begins to run when the state litigation ends. In Reed's case, the statute of limitations began to run when the Texas Court of Criminal Appeals denied Reed's motion for rehearing. Reed's Section 1983 claim was timely. We reverse the judgment of the U.S. Court of Appeals for the Fifth Circuit. It is so ordered. Justice Thomas, dissenting. The Texas Court of Criminal Appeals, CCA, affirmed the denial of petitioner Rodney Reed's state law motion for post-conviction DNA testing. Reed petitioned this court for certiorari, arguing that the CCA's interpretation and application of the relevant state law violated his federal due process rights. After we denied his petition, Reed repackaged it as a complaint in federal district court, naming respondent, the Bastrop County District Attorney, as a placeholder defendant. Like his earlier certiorari petition, Reed's complaint assails the CCA's state law reasoning as inconsistent with due process, and it seeks a declaration that the CCA's interpretation and application of state law was unconstitutional. Reed's action should be dismissed for lack of subject matter jurisdiction. Federal district courts lack appellate jurisdiction to review state court judgments, and Reed's action presents no original Article III case or controversy between him and the district attorney. Because the court erroneously holds that the district court had jurisdiction over Reed's action, I respectfully dissent. On April 23, 1996, 19-year-old Stacy Stites failed to report for her 3:30 a.m. shift at the H-E-B grocery store in Bastrop, Texas. The truck Stites drove to work was found abandoned in the Bastrop High School parking lot a couple of hours later. That afternoon, a passerby discovered Stites' body in a ditch by a country road, her clothing disturbed in a manner suggesting sexual violence. Medical examiners determined that Stites had been strangled to death with her own belt, which was found in two pieces, one near the truck, the other near Stites' body. There was semen in Stites' vagina and rectum and saliva on her breasts. The police concluded that Stites had been raped and murdered. Despite a wide-ranging investigation, the police were initially unable to find a DNA match for the bodily fluids recovered from Stites' corpse. Then, about 6 months after Stites' death, Reed was arrested for kidnapping and attempting to rape and murder another young woman near the route Stites typically took to work, and around the same time of night when Stites had gone missing. Reed lived near the high school, and was often seen walking the surrounding area at night. Intrigued, the police checked Reed's DNA profile, which Texas had on file from an earlier sexual assault case against him. A series of tests established a conclusive, one in the world population match between Reed and the fluids recovered from Stites' corpse. When first questioned, Reed insisted that he did not know Stites at all, unaware that the police had DNA evidence disproving that claim. By the time of his trial, he had changed his story. He and Stites were having a consensual affair, and someone else, perhaps her jealous fiancé, had committed the murder. The jury rejected that post hoc narrative and found Reed guilty. In the separate penalty phase, Reed's kidnapping victim testified about how Reed had abducted, threatened, and attempted to rape her before she was fortuitously able to escape. 4 other women, and one underage girl, also testified that Reed had brutally beaten and raped them in the past. Reed was sentenced to death. The CCA affirmed Reed's conviction and sentence in 2000. In the 23 years since, he has kept up a constant stream of post-conviction filings asserting his innocence. Every few years, Reed's lawyers have produced a new theory and a new purportedly exculpatory affidavit. With the patience of Job, the Texas courts have duly considered them all. On one such occasion, the CCA noted the complete lack of a cohesive theory of innocence across Reed's unending series of attempts to relitigate his guilt. In Texas, a convict has 2 distinct avenues to obtain post-conviction DNA testing of evidence, one executive and discretionary, the other judicial and legal. As for the first, the convict can attempt to reach an agreement with the district attorney, who has broad discretion to order or allow DNA testing. In the case of the second, the convict can file a motion under Texas Code of Criminal Procedure which requires the convicting court to order testing if the movement establishes certain requirements. In 2014, on the same day that the trial court held a hearing to set Reed's execution date, Reed filed a Chapter 64 motion for DNA testing of a large number of items. The district attorney consented to test some of the items outside of the Chapter 64 framework, but he otherwise opposed Reed's request. The trial court denied the motion, finding that Reed had not established 2 necessary elements for Chapter 64 testing. 1. That he would not have been convicted if exculpatory results had been obtained through DNA testing, and 2. That his Chapter 64 motion was not made to unreasonably delay the execution of sentence or administration of justice. Reed appealed, and the CCA remanded for the trial court to address the other elements of the Chapter 64 rubric. After making supplemental findings, the trial court again denied Reed's motion, and Reed again appealed. In April 2017, the CCA issued an opinion affirming the trial court. First, The CCA held that the record supported the trial court's finding that many of the items had not been subjected to a chain of custody sufficient to establish that they had not been substituted, tampered with, replaced, or altered in any material respect. Second, it held that Reed had not shown a reasonable likelihood that many of the items contained biological material suitable for DNA testing. Third, addressing only the items that survived the previous two holdings, the CCA held that Reed had not established that exculpatory results from DNA testing of those items would have prevented his conviction. Finally, the CCA held that Reed had failed to establish that his Chapter 64 motion was not made for purposes of delay. The CCA noted that Chapter 64 had existed with only slight variations for over 13 years at the time Reed filed his motion, and that Reed's motion was suspiciously filed on the same day the judge heard the state's motion to set an execution date. Reed moved for rehearing, arguing that the CCA had misapplied the Chapter 64 elements and asserting, in broad terms, that those errors violated his due process rights. The CCA denied rehearing by summary order in October 2017. Reed then timely petitioned this court for a writ of certiorari to review the CCA's judgment. His petition contended that the CCA's judgment violated his due process rights because it was based on arbitrary and fundamentally unfair interpretations of Chapter 64's chain of custody and unreasonable delay elements. In August 2019, Reed sued the district attorney under Section 1979, 42 U.S.C. Section 1983 in the U.S. District Court for the Western District of Texas. As relevant here, Reed's complaint alleges that he successfully proved each of the statutory requirements of Chapter 64 in the state court proceedings, but that the CCA's adoption of non-statutory criteria to preclude Reed from testing key trial evidence to prove his innocence violated fundamental notions of fairness and denied him due process of law. Reed proceeds to allege several ways in which the CCA's interpretation and application of Chapter 64 violated fundamental fairness, with particular focus on the CCA's allegedly arbitrary constructions of the chain of custody, unreasonable delay, and exculpatory results elements. For relief, Reed seeks a declaration that Chapter 64, as interpreted, construed, and applied by the Texas courts to deny his motion for DNA testing, violates his rights under the Constitution. The district attorney moved to dismiss Reed's complaint for lack of subject matter jurisdiction and for failure to state a claim. The district court held that it had jurisdiction but dismissed Reed's complaint on the merits, concluding that Reed had alleged only that he disagreed with the state court's construction of Texas law, and that none of the issues in the complaint rose to the level of a procedural due process violation. The Fifth Circuit affirmed on the alternative ground that Reed's claim was untimely, applying Texas' 2-year statute of limitations for personal injury claims. It reasoned that Reed's due process claim accrued when the trial court first denied his Chapter 64 motion, rendering his complaint several years too late. Two intertwined principles of federal jurisdiction, Article 3 standing and the Rooker-Feldman doctrine, mandate a finding that the district court lacked jurisdiction over this action. The majority gives short shrift to these principles, and its holding that Reed's claim was timely serve only to underscore its antecedent jurisdictional errors. The Constitution limits the federal court's jurisdiction to cases and controversies. Article 3 Section 2 Clause 1, constraining judicial power to the determination of real, earnest and vital controversies between contending litigants. An essential and unchanging part of this case or controversy requirement is the doctrine of Article 3 standing. Under that doctrine, any party requesting relief from a federal court must assert an injury that is concrete, particularized, and actual or imminent, and he must show that his injury is both fairly traceable to the challenged action and redressable by a favorable ruling. Absent that showing, the court has no jurisdiction and thus no power to adjudicate the case. Jurisdiction, moreover, comes in two types, original and appellate, and the application of the Article 3 standing elements is interwoven with that constitutionally grounded distinction. In an original case or controversy, the plaintiff traces his injury to the defendant's allegedly unlawful conduct, and correspondingly, seeks a remedy that runs against the defendant and determines that defendant's duties or liabilities, e.g., a judgment for money damages or an injunction. On the other hand, the criterion which distinguishes appellate from original jurisdiction is that it revises and corrects the decisions of another tribunal. As such, a case or controversy is appellate in nature when the relief-seeking party's injury is traceable to the allegedly erroneous action of another court and requires a remedy correcting that judicial action. For example, reversal or vacatur of the challenged judgment. Thus, whenever a party seeks relief from a federal court, the elements that bring his claim within Article 3 in the first place, the nature and source of his injury and the remedy needed to redress it, also dictate whether his claim invokes original or appellate jurisdiction. The conceptual distinction between original and appellate jurisdiction also animates the Rooker-Feldman doctrine, which, despite its name, is not so much a doctrine as a basic fact of federal statutory law. This court has discretionary appellate jurisdiction to review certain state court judgments by certiorari, but no other federal court has appellate jurisdiction over state court judgments, and, in particular, the jurisdiction possessed by the district courts is strictly original. Thus, if the losing party in a state judicial proceeding claims that the state judgment itself violates his federal rights, a claim that calls for an exercise of appellate jurisdiction, his only remedy in the federal system is certiorari in this court. He may not seek what in substance would be appellate review of the state judgment under the guise of an original action in federal district court. Yet, that is precisely what Reed has done here. While his complaint purports to bring an original action against the district attorney, in reality, it seeks appellate review to redress an alleged injury inflicted by the CCA's adverse decision in his particular case. The gravamen of Reed's claim, made clear again and again throughout his complaint, is that the CCA violated his due process rights through its reasoning in his case. All of those alleged injuries are traceable to the CCA, not the district attorney, and redressing them would require an exercise of appellate jurisdiction over the CCA, jurisdiction that the district court does not have. Confirming the point, Reed's complaint does not ask the district court to control the district attorney's actions at all. Instead, the only relief it requests is a declaration that the CCA's interpretation and application of Chapter 64 is unconstitutional. The complaint transparently seeks nothing more than the district court's review and rejection of the CCA's judgment. As such, it founders upon the Rooker-Feldman doctrine as well as the Article 3 traceability and redressability requirements with which that doctrine is intertwined. Any doubt that Reed seeks de facto appellate review should be dispelled by one undisputed fact. Every due process violation that Reed alleges could have been considered on direct review of the CCA's judgment in this court. After all, determining whether state court judgments applied unconstitutional constructions of state law is a classic use of this court's appellate jurisdiction under Section 1257A. That is why Reed originally petitioned this court for certiorari to review the CCA's judgment, and it is why he agreed at oral argument that we could have granted that petition. Yet, even after repackaging his failed certiorari petition as an original Section 1983 complaint, Reed not only concedes but affirmatively argues that his claim is analogous to the due process arguments presented in Rogers, Bowie, and Brinkerhoff-Ferris. That he is correct on that front should be fatal to his complaint. Like the petitioners in those cases, Reed contends that the rules of decision applied against him in a state court proceeding violated his due process rights. Because those contentions would have been appropriate subjects for this court's appellate review, it follows that Reed cannot press the same due process challenges and seek the same relief in an original action in the district court. In holding otherwise, the majority improperly separates the Rooker-Feldman and Article 3 inquiries and applies a different theory of Reed's claim to each. But Reed's claim must satisfy two conditions at once. It must implicate an Article 3 case or controversy between the parties to this action, and that case or controversy must fall within the district court's strictly original jurisdiction. The majority articulates no theory of how Reed's claim can satisfy both conditions. That is because there is no such theory. A useful way to view this is to work backwards from the majority's Rooker-Feldman holding. The majority accepts Reed's representation that he does not challenge the adverse state court decisions themselves, but only targets as unconstitutional the Texas statute Chapter 64 they authoritatively construed. But this workaround to Rooker-Feldman raises a glaring Article 3 problem. As this court has repeatedly explained, a federal court may not entertain a free-floating challenge to a statute unmoored from a concrete case or controversy. Unless Reed merely seeks an advisory opinion, his due process challenge to Chapter 64 must seek relief from some concrete enforcement or application of that law that affects him. More specifically, Reed must be challenging either 1. Some conduct of the district attorney constituting enforcement of Chapter 64 against him, or 2. The CCA's application of Chapter 64 as a rule of decision in his case. If it is the former, Reed's suit is original. If it is the latter, it requires an exercise of appellate jurisdiction. So, which is it? As already indicated, the correct answer is the latter. Fundamentally, Reed's complaint, like his certiorari petition before it, contests how the Texas courts interpreted, construed, and applied Chapter 64 to deny his motion for DNA testing, which is why the only relief he requests is an abstract declaration that the CCA's interpretation and application of Chapter 64 is unconstitutional. The idea that his claim does not challenge the adverse state court decisions cannot survive even a cursory examination of his complaint, nor would the other possibility make any sense. Reed cannot be seeking relief from the district attorney's enforcement of Chapter 64, because the district attorney has not enforced that law against Reed at all. The sum total of the district attorney's relevant conduct is as follows. First, he declined to order Reed's desired testing in his executive discretion, independent of Chapter 64. Next, when Reed asked the Texas courts to grant testing under Chapter 64, the district attorney opposed his motion. Finally, after Reed's motion proved unsuccessful, the district attorney continued to decline to order Reed's desired testing. To say that this conduct amounts to enforcing Chapter 64 makes as much sense as saying that a party to a discovery dispute, who defeats a motion to compel in effect, enforces the federal rules of civil procedure by continuing not to turn over the demanded documents. Again, any due process injury that Chapter 64 has caused Reed is traceable to the CCA's judicial application of that law in his case, not to any executive acts or omissions of the district attorney. The majority permits Reed to evade that problem by framing his Article 3 injury as the mere lack of access to his desired evidence, independent of any alleged due process denial. But, if framing Reed's injury that way helps with traceability, it only worsens his redressability problem. Suppose that the district court accepted Reed's due process arguments and issued his requested relief, an abstract declaration that the interpretation of Chapter 64 that the CCA applied in his case is unconstitutional. How exactly would that redress Reed's injury of not having the evidence tested? The CCA's Chapter 64 judgment would remain untouched. Reed would have obtained an opinion disapproving its reasoning, but without any appellate revision and correction to disturb its finality. Nor would a declaration that the CCA's construction of Chapter 64 was unconstitutional imply anything about the district attorney's duties or liabilities. The majority asserts that such a declaration would cause a significant increase in the likelihood that the district attorney would grant Reed's desired testing. But the district attorney has made clear that he does not understand Reed's requested relief to require any change in conduct from him, and that it is not likely to bring about such change. If the majority thinks the district attorney is wrong about that, it would only be fair to explain exactly what change in conduct would be legally required of him if Reed prevailed on his due process claim. The majority fails to do so. Instead, it offers a number of vague pronouncements, all of which wilt under scrutiny. Consider the claim that Reed's victory in this action would eliminate the district attorney's justification for denying DNA testing. If this means that Reed's requested relief would entitle him to testing under Chapter 64, it is wrong because the CCA's unreversed judgment would stand as a final, binding determination of Reed's Chapter 64 rights even if the district court were to declare that, in its opinion, the CCA had applied that law unconstitutionally in Reed's case. Alternatively, if the majority means that the success of Reed's due process claim would require the district attorney to permit testing in his independent executive discretion, it is also wrong because Reed is not challenging the district attorney's denial of discretionary testing as unlawful, only the CCA's interpretation and application of Chapter 64. The majority also misses the mark when it asserts that it is substantially likely that the district attorney would abide by Reed's requested court order. Ante, at 3, internal quotation marks omitted. Again, the only court order Reed seeks is a declaration disapproving the legal underpinnings of the CCA's judgment. Such an order would have no bearing on the district attorney's future conduct. In a literal sense, there would be nothing for him to abide by. Finally, the majority says that the district court would have ordered a change in a legal status were it to grant the declaration Reed seeks. The intended meaning of this statement is completely obscure. The status that the majority has in mind cannot be that of Chapter 64 itself, nor can the majority mean that the district court could change the status of the CCA's judgment. In reality, the only way that the district court could possibly help Reed obtain DNA testing is by directly controlling the district attorney's actions. But, again, Reed's complaint neither requests nor sets forth a basis for any such relief. In sum, there is no getting around the essential problem with Reed's due process claim. To the extent he is not merely seeking an advisory opinion, he is complaining about a court-inflicted injury, and redressing that injury would require an exercise of appellate jurisdiction that the district court does not possess. In substance, his complaint in this action is a mere reprise of his prior certiorari petition, camouflaged as an original action against the district attorney. Thus, I would vacate the Fifth Circuit's judgment and remand this case to the district court with instructions to dismiss the complaint for lack of subject matter jurisdiction. The majority next holds that Reed's Section 1983 due process claim was timely because it did not accrue until the CCA denied rehearing. The little reasoning the majority offers for this conclusion helpfully accentuates its antecedent jurisdictional errors. First, the majority points out that a procedural due process claim is not necessarily complete when the deprivation occurs, but only when the state fails to provide due process. Yet the general rule is that due process itself requires pre-deprivation notice and hearing. So the truism for which the majority quotes Zienerman matters only in those extraordinary situations in which we tolerate post-deprivation process as sufficient. The majority proceeds to show, however, that it does not regard this case as a post-deprivation case at all, for it says that the state deprived Reed of his asserted liberty interest in DNA testing at the very moment when the state's alleged failure to provide Reed with a fundamentally fair process was complete. Given this understanding of Reed's claim, the important proposition with which the majority begins its analysis is doctrinally irrelevant. After that red herring, the majority engages in an obvious equivocation, conflating the Chapter 64 process that Reed challenges as fundamentally unfair with the Texas court's generally applicable decisional procedures. But of course, those procedures are not what Reed challenges. Instead, and, again, exactly like the arguments in his prior certiorari petition, his due process claim targets as unconstitutional the substantive requirements of Chapter 64 as construed. His claim plainly would be no different if the CCA did not entertain rehearing motions. Still, the majority's confused accrual reasoning is useful for the added light that it shines on Reed's jurisdictional problems. As the majority says, a procedural due process claim has two elements: 1, a deprivation, and 2, inadequate process. The majority then acknowledges that the state courts effectuated Reed's deprivation, and it treats the state court's ordinary decisional mechanics as the allegedly inadequate process. But, after both elements of Reed's claim are thus laid at the feet of the state courts, what role is left for the nominal defendant here, the district attorney? What part did he play in violating Reed's procedural due process rights, and what makes him a proper defendant to Reed's Section 1983 claim? The majority has no answer. At bottom, its approval of Reed's claim is intelligible only upon the supposition that the district attorney may be sued as a mere stand-in for the state as a whole, such that Reed can urge against him the due process violations that the state allegedly committed through its courts. That is a profound mistake. True, the district attorney and the CCA are both state actors. But, states act in different ways through their different entities and officers, and the nature of a challenged state action determines what federal court remedy may be available. As this court has explained, a state acts by its legislative, its executive, or its judicial authorities, and in no other way. The Due Process Clause applies to action through any of these agencies, but not every alleged due process violation may be asserted in an original Section 1983 action. By itself, a state's legislative enactment of an unconstitutional law does not give rise to a justiciable case or controversy. Next, when a state allegedly violates due process through executive action, the aggrieved party may bring an original action for appropriate relief against the relevant executive officer. And, when a state allegedly violates due process through its judicial actions, be it through the denial of a fundamentally fair judicial procedure, or through the application of a rule of decision that itself violates due process, the remedy that Congress has provided is appellate review of the challenged judgment in this court. But, if that remedy proves unsuccessful as it did for Reed, the aggrieved party cannot simply substitute an executive officer as a defendant, charge the state court's errors to that officer, and seek redress for a court-inflicted injury in a purported original action. Properly understood, therefore, Article 3, the Rooker-Feldman Doctrine, and procedural due process principles work in harmony. The majority's piecemeal analysis replaces this natural coherence with chaos. It dilutes Article 3's traceability and redressability requirements to the point of irrelevance. It creates a system in which the same state court actions simultaneously give rise to identical original and appellate claims for relief. It allows Reed to convert his failed certiorari petition into a Section 1983 complaint, and, in doing so, it authorizes a proceeding in which the district court can do nothing except opine on the constitutional merits of a state court adjudication. If there is a mitigating factor to today's decision, it is that the Section 1983 action that the court misguidedly allows to proceed is no barrier to the prompt execution of Reed's lawful sentence. Indeed, Reed conceded at oral argument that you do not get a stay of execution just because you brought a Chapter 64 proceeding, or just because you're in Section 1983 proceedings, challenging the adequacy of the procedures available to you from the state. Texas is free to take him at his word. But because the majority undermines vital principles of federal jurisdiction and destabilizes the orderly working of our judicial system, I respectfully dissent. Justice Alito, with whom Justice Gorsuch joins, dissenting. This case involves a suit brought by petitioner Rodney Reed under Reverend Stat. Section 1979, 42 U.S.C. Section 1983, against Brian Goertz, the district attorney of Bastrop County, Texas. Reed claims that Goertz violated his due process rights when, based on the Texas Court of Criminal Appeals interpretation of the Texas statute that allows post-trial DNA testing under specified circumstances, Article 64 of the Texas Code of Criminal Procedure, Goertz continued to deny Reed's request for DNA testing of certain items found near the scene of the murder for which he was convicted 25 years ago. As the court notes and the parties agree, the statute of limitations for Reed's claim is 2 years. Reed filed his complaint on August 8, 2019, and the lower courts held that this was too late. The question before us is when the 2-year statute of limitations began to run, that is, in legal parlance, when Reed's claim accrued. As the parties agree, the general rule is that a claim accrues when the plaintiff has a complete and present cause of action. Reed contends that his claim did not accrue until the Texas Court of Criminal Appeals, CCA, denied his petition for rehearing on October 4, 2017, and thus refused to retract the interpretation of Article 64 that the court had unanimously adopted on April 12, 2017. Goertz, on the other hand, argues that Reed's claim accrued no later than the date of the CCA's April 12 decision, and because that date preceded the federal lawsuit by more than 2 years, Goertz maintains that we should affirm the Fifth Circuit's decision that Reed's complaint was filed too late. As I will explain, there is room for debate about exactly when Reed's DNA testing claim accrued, but in my view, the notion that this did not take place until rehearing was denied is clearly wrong. Before getting to the nub of this case, I briefly explain why Reed's claim might have accrued even earlier than April 12, 2017. First, it can be argued that Reed's claim against Goertz accrued on or before July 2014, when Goertz initially refused Reed's testing request. Another possibility is that the particular claim Reed now asserts did not accrue until the state trial court held that Goertz had properly denied Reed's testing request. For present purposes, it is not necessary to decide whether Reed's claim accrued on either of these two dates. We need only decide whether accrual was put off until the CCA denied rehearing. And it is clear to me that this delayed accrual date is wrong. As noted, the claim that Reed asserts is not based on the bare text of Article 64, but on what he claims is an erroneous interpretation of that provision by the Texas courts. He thus submits that his claim accrued when the authoritative construction of Article 64 that he challenges was pronounced by the CCA. I will assume for the sake of argument that Reed's claim accrued when the CCA issued its authoritative construction of Article 64, but I cannot agree with Reed's argument that the CCA's interpretation did not become authoritative until rehearing was denied. Reed cites no authority for the proposition that the filing of a petition for rehearing typically suspends the authoritative force of an appellate court's decision, and in fact, it appears that the opposite is true, as this court's GVR practice illustrates. On or shortly after the day when we hand down a decision, we often GVR cases in which petitions raising similar issues are pending before us. That is, we grant the petition, vacate the decision below, and remand the case for reconsideration in light of the decision we have handed down. On June 30, 2022, for example, we did this in no fewer than 33 cases. What? Do not wait to see if a petition for rehearing will be filed, nor do we hold off until a mandate is issued or a certified copy of the judgment is prepared. See this Court's Rules 45.2 and 45.3. If our decisions did not become authoritative and binding as soon as they are issued, this practice would be impermissible. There is no reason why decisions of the CCA should be viewed any differently. On the contrary, it appears that the CCA has followed a practice similar to our GVR practice, and neither Reed nor the court has cited any contrary Texas authority. Accordingly, Reed's authoritative construction argument became complete, at the latest, when the CCA adopted that construction on April 12, 2017, 2 years and 11 months before Reed filed his Section 1983 complaint. Unlike Reed, the court does not contend that the CCA's interpretation lacked authoritative status until rehearing was denied. Instead, the court merely proclaims that the state, acting through Goertz, did not deny Reed due process of law until the state litigation ended. I certainly see the logic in this view, until the process afforded by a state has been exhausted. It may be said that the state has not definitively denied the process that the Constitution is alleged to demand. This logic leads to the conclusion that a prisoner like Reed should exhaust state remedies, something that would generally be required if the proper vehicle for contesting the denial of a DNA testing claim were a petition for a writ of habeas corpus. But the court rejected that proposition in District Attorney's Office for 3rd Judicial District v. Osborne, and it is well established that a Section 1983 plaintiff need not exhaust state remedies. Not only is this the general rule, but the Osborne court found that the rule applies in cases involving constitutional challenges to the denial of requested DNA testing. Thus, the court's reasoning collides with precedent. On top of this, the court's reasoning, if taken to its logical conclusion, points to a result that neither Reed nor the court is willing to embrace, namely, that a due process challenge to the denial of a request for DNA testing is not ripe until state remedies have been exhausted. Reed squarely rejects that conclusion, and the court reserves judgment. But that is where the court's reasoning is likely to lead. Reed? tries to circumvent this problem by distinguishing between a claim that challenges the literal terms of a state law and one that challenges the law as authoritatively interpreted by the state's highest court. On this view, only claims of the latter type would have to proceed through the entire state court appellate process before a Section 1983 challenge could be brought. But this categorization of DNA testing claims is problematic. When a state's high court interprets a state law, it generally settles what the law always meant, and therefore it is hard to see the difference between a claim that the text of a state statute is unconstitutional and a claim that the text is unconstitutional as interpreted by the state's highest court. In the case of a state law like Article 64, which permits DNA testing under limited circumstances, the court may interpret the statute to impose requirements that are not expressly spelled out in the statutory text. That is what happened here. Or the state high court may interpret requirements in the text more leniently than a literal reading of the text would demand. In either event, the statute means what the state high court says it means, and if accrual in the first of these situations does not take place until the end of appellate review, it is hard to see why the same should not be true in the second as well. In light of these problems, it is not surprising that the court declines to say anything about whether prisoners who wish to challenge a state DNA testing law may sue as soon as their testing requests are denied. The court says only that it need not address the hypothetical scenario of a plaintiff who declines full appellate review. But what does that mean? Does it mean that such a plaintiff must exhaust state remedies at the trial level but need not appeal? Does it mean that such a plaintiff must pursue some but not full appellate review? Litigants and the lower courts are left to guess. Instead of clarifying the law, the court's decision may sow confusion. Much of Reed's argumentation is not aimed at the argument that his claim accrued when the CCA issued its contested interpretation of Article 64. Instead, Reed directs his attack on the earlier, possible accrual dates discussed in Part 1 of this opinion, and in particular the Fifth Circuit's holding that a claim like Reed's accrues when testing is denied at the trial level. He says that this rule is unfair because he isn't Nostradamus, lacks supernatural foresight, and therefore could not have predicted at the time of the trial court decision whether the CCA would ultimately agree. He argues that his rule promotes federalism, because it encourages resort to state court litigation before turning to the federal courts. Judicial economy, because it tends to avoid contemporaneous litigation in both state and federal court. Comedy, because it allows state courts to adopt interpretations of their statutes that avoid federal constitutional problems. And practical reality, because a prisoner bringing an authoritative construction claim cannot know in advance how a state's high court will interpret the relevant statute. The court makes related arguments. Whatever merit these arguments might have in relation to the accrual date adopted by the Fifth Circuit, they ring hollow as applied to the choice between the date when a state high court issues a decision interpreting the state testing statute and the date when that court refuses to rehear and overturn that interpretation. One need not have supernatural foresight in order to predict that rehearing is unlikely to be granted, and it is hard to see how requiring a Section 1983 plaintiff to sue within 2 years after a state high court decision is issued is unfair, or does any damage to federalism, comedy, or judicial economy. Reed has provided no explanation why he could not have filed his Section 1983 action within 2 years after the CCA's decision. Instead, he waited until an execution date was set. While that event may have concentrated his mind wonderfully, that is not an excuse for the basic mistake of missing a statute of limitations. For these reasons, I would affirm the judgment below, and I therefore respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.